When did reporting your boss get you arrested? The police arrested me at my apartment at 6:15 a.m. on a Friday morning in early November, 3 days after I filed a formal OSHA complaint against my supervisor at Riverside Distribution Center. I was still in my pajamas when two officers knocked on my door, showed me a warrant, and told me I was being charged with felony theft of company property valued at over $50,000. Detective Frank Kowalski read me my rights while his partner searched my apartment, looking for stolen electronics and inventory that I'd supposedly been taking from the warehouse for the past 6 months. I stood in my living room in shock, trying to process what was happening, while they photographed my belongings and confiscated my laptop. When I said there must be a mistake, that I hadn't stolen anything, Detective Kowalski told me the company had surveillance footage, inventory records, and witness statements proving otherwise. He said my supervisor, a man named Craig Donovan, had been documenting my thefts for months, and finally reported me when the total reached felony levels. I was handcuffed and taken to the county jail, booked on charges of grand theft and embezzlement, and held on $75,000 bail that I couldn't afford to pay. I'd worked at Riverside Distribution Center for 3 years as a warehouse supervisor, managing a team of 18 workers who loaded and unloaded freight trucks 6 days a week. The job was physically demanding and the pay was modest, but I'd been good at it, receiving positive performance reviews and even a small promotion last year. Craig Donovan had been my direct supervisor for the past 14 months, hired from outside the company to improve efficiency and reduce costs. From the beginning, Craig had cut corners on safety procedures, pressuring workers to move faster, to stack pallets higher than regulations allowed, to operate forklifts without proper certification. I'd pushed back multiple times, citing safety protocols and OSHA requirements, and Craig had dismissed my concerns every time. He told me I was too cautious, that we needed to meet productivity targets or the company would start laying people off. When workers started getting injured with increasing frequency, I knew I had to do something. In the past 6 months, 12 workers on my shifts had suffered workplace injuries ranging from minor cuts and sprains to serious incidents requiring hospitalization. A man named Luis Gutierrez broke his leg when an improperly stacked pallet collapsed on him. A woman named Jennifer Park suffered a concussion when she fell from a loading dock that should have had safety railings but didn't because Craig said they slowed down operations. 3 people developed repetitive stress injuries from being forced to work without adequate breaks. I documented every incident, took photos of safety violations, recorded the dates and times when Craig explicitly ordered us to ignore safety procedures. When I tried to report the problems to Human Resources, the HR manager told me that Craig had full authority over warehouse operations and that my job was to follow his directions, not question them. So I went above the company and filed a formal complaint with OSHA, detailing the systematic safety violations and attaching my documentation as evidence. The OSHA complaint was filed on Monday afternoon. By Thursday evening, I received a terse email from Craig summoning me to a meeting with him and the company's operations director first thing Friday morning. I assumed they'd found out about the OSHA complaint and were going to retaliate, maybe write me up for insubordination, or try to intimidate me into withdrawing it. I'd prepared myself for that confrontation, ready to stand my ground and cite whistleblower protection laws. Instead, the police showed up at my door at dawn and arrested me for crimes I hadn't committed. Sitting in a jail cell that Friday afternoon, waiting for my arraignment hearing, I understood that Craig hadn't just retaliated. He'd destroyed me. A felony theft conviction would mean prison time, a permanent criminal record, and the end of any career in logistics or warehouse management. Even if I was eventually acquitted, the arrest itself would follow me forever, showing up in background checks and ruining job prospects. My arraignment happened Monday morning. I stood before Judge Margaret Leland in an orange jumpsuit, exhausted from 3 nights in jail, while a prosecutor named Aaron Klein outlined the charges against me. He said that Riverside Distribution Center had discovered systematic theft of company inventory dating back 6 months, that surveillance footage showed me removing boxes of electronics from the warehouse during night shifts, and that inventory audits revealed over $52,000 in missing merchandise that I'd been responsible for securing. The prosecutor said I'd been selling the stolen goods through online marketplaces and pocketing the money. He characterized me as a trusted employee who'd betrayed the company's confidence and stolen from my employer while in a position of responsibility. He requested high bail, citing me as a flight risk with access to stolen funds. My court-appointed attorney, a young public defender named Lisa Moreno, argued that I had no criminal history and strong ties to the community, but the judge set bail at $50,000, which I had no way of paying. Lisa visited me in jail that afternoon and we talked through the details of the case. She'd received the initial discovery documents from the prosecutor's office, and they were damning. Surveillance footage allegedly showing me loading boxes into my personal vehicle on multiple dates. Inventory records documenting missing merchandise from sections of the warehouse I supervised. Witness statements from coworkers claiming they'd seen me acting suspiciously and removing items without authorization. Lisa asked if any of it could be legitimate, if there was any chance the company had genuine evidence of theft. I told her absolutely not, that I'd never stolen anything, that this was retaliation for filing the OSHA complaint. But Lisa's expression showed she'd heard similar claims from other clients who turned out to be guilty. She said we'd need to review all the evidence carefully and build a defense, but warned me that if the surveillance footage was clear, we might need to consider a plea deal to avoid the worst consequences. I called my sister Maya that evening from the jail's phone system, using up most of my limited funds to explain what had happened. Maya was a paralegal at a civil litigation firm downtown, and she understood immediately that something was wrong. She asked specific questions about the timeline, about Craig's response to my OSHA complaint, about whether the company had any legitimate basis for theft accusations. When I said no, that I'd never taken anything, and that the charges appeared 3 days after I reported safety violations, Maya told me this sounded like a setup. She said she'd talk to attorneys at her firm and see if anyone could help, that there had to be more to this than the prosecution was claiming. She also said she'd try to raise bail money by reaching out to family members and possibly taking out a loan against her car. Hearing her voice, hearing someone believe me unconditionally, made me break down crying for the first time since the arrest. Maya managed to post bail on Wednesday afternoon, using money scraped together from relatives and a high-interest loan. I walked out of jail after 5 days, blinking in the bright November sunlight, wearing the same clothes I'd been arrested in. Maya drove me back to my apartment, which was still in disarray from the police search, with belongings scattered and my electronics seized as evidence. We sat at my kitchen table and she showed me what she'd discovered. Her law firm had connected her with a criminal defense attorney named Gary Brennan, who specialized in wrongful prosecution cases. Gary had agreed to review my case pro bono after Maya explained the circumstances. He'd already started looking into Craig Donovan's background and Riverside Distribution Center's operations, and he'd found several red flags that suggested the theft charges might be fabricated to silence my OSHA complaint. Gary Brennan met with me the next day at his office downtown. He was in his 50s with sharp eyes and a reputation for taking on difficult cases against powerful institutions. He listened to my entire story without interrupting, taking notes on a legal pad, occasionally asking clarifying questions. When I finished, he leaned back in his chair and told me he believed I was innocent and that this prosecution was likely a coordinated effort to destroy my credibility before the OSHA investigation could proceed. But he also warned me that proving innocence would be difficult because the prosecution had apparently strong evidence. We needed to attack the evidence itself, show it was fabricated or manipulated, and expose why Craig and the company would go to such lengths to frame me. Gary said his investigator would start examining the surveillance footage, inventory records, and witness statements, looking for inconsistencies or signs of manipulation. The investigator, a woman named Rachel Torres, was a former police detective who'd worked fraud cases for 20 years before going private. She met with me at Gary's office and asked detailed questions about the warehouse operations, the surveillance system, inventory tracking procedures, and my relationship with coworkers. She wanted to understand exactly how the warehouse functioned so she could identify whether the alleged theft would have even been possible given the security measures in place. I explained that the warehouse had cameras covering all loading areas and exits, that inventory was tracked through a digital system requiring supervisor authorization for any removals, and that security guards checked vehicles leaving the property. If I'd actually been stealing merchandise, dozens of people and multiple systems would have detected it immediately. Rachel nodded and said that was exactly the kind of detail she needed. Rachel obtained the surveillance footage through discovery requests and spent 3 days analyzing every frame. When she called Gary and me back to his office, she had a presentation prepared on her laptop that made my blood run cold. The footage the prosecution had provided showed me loading boxes into my car on 6 different dates over the past 4 months. The timestamps were clear, the images showed my face and my vehicle's license plate, and the boxes were labeled with company inventory tags. It looked absolutely damning. But Rachel had found something crucial. She'd compared the metadata embedded in the video files with the security system's logs from the warehouse. The metadata showed the footage had been edited and compiled from different source files on October 28th, 2 days before my OSHA complaint and 5 days before my arrest. Someone had taken legitimate footage of me doing normal work activities, isolated clips of me carrying boxes, and assembled them into a compilation that looked like evidence of theft. Rachel pointed to specific frames where the lighting was inconsistent, where shadows fell at angles that didn't match the timestamps, where the background showed seasonal details that contradicted the alleged dates. In one clip, supposedly from July, the parking lot visible behind me showed autumn leaves and workers wearing jackets. In another clip, supposedly from August, my clothing didn't match weather records from that date. Most damning, Rachel had found several clips where I was carrying boxes that inventory records showed had been legitimately removed with proper authorization for delivery to retail clients. The footage wasn't fake, but it had been deliberately edited and recontextualized to make legitimate work look like theft. Rachel said this kind of manipulation required access to the security system and technical knowledge to edit video metadata. She suspected someone in the warehouse's security department or IT department had created the fabricated evidence at Craig's direction. Gary immediately filed a motion to dismiss the charges, citing newly discovered evidence that the prosecution's surveillance footage had been manipulated and fabricated. He attached Rachel's forensic analysis showing the metadata discrepancies, the lighting inconsistencies, and the proof that the footage had been compiled days before my OSHA complaint. The motion argued that I was being prosecuted based on manufactured evidence created specifically to retaliate against a whistleblower, and that continuing the prosecution would constitute malicious persecution. Prosecutor Aaron Klein opposed the motion, arguing that metadata could be unreliable and that minor inconsistencies didn't prove the footage was fabricated. But Judge Leland ordered an evidentiary hearing to examine the surveillance evidence more thoroughly. The hearing was scheduled for 3 weeks out, giving both sides time to prepare expert testimony about the video analysis. While Gary prepared for the hearing, I started reaching out to coworkers from the warehouse, trying to understand who had provided witness statements claiming I'd stolen merchandise. Maya helped me compile a list of everyone on my shifts, and I called them one by one. Most were sympathetic but scared to get involved, worried about losing their own jobs if they contradicted the company's version of events. But a few were willing to talk, and what they told me revealed a disturbing pattern. Several workers said they'd been pressured by Craig to sign statements saying they'd seen me acting suspiciously or removing items without authorization. They'd been told the company was investigating inventory discrepancies and needed their cooperation. Some had refused to sign, but others had agreed because they were afraid of retaliation if they didn't comply. One worker, a man named Terrell Johnson, told me that Craig had showed him edited surveillance footage during their meeting and told him the footage proved I was stealing, so signing a statement was just confirming what the video already showed. Terrell agreed to meet with me and Gary, and his testimony was explosive. He explained that Craig had called several workers into his office individually during the week before my arrest, showed them edited video clips, and asked them to confirm they'd witnessed suspicious behavior from me. Some workers had questioned why they were being asked to sign statements when they hadn't actually seen anything wrong, but Craig had implied their jobs were at risk if they didn't cooperate with the investigation. Terrell had signed a statement saying I'd removed boxes from the warehouse on dates he wasn't even working, but Craig had told him not to worry about specific dates because the surveillance footage would provide the precise timeline. Gary asked Terrell if he'd be willing to recant his statement and testify about the pressure Craig had applied. Terrell hesitated, knowing it could cost him his job, but finally agreed because he said what was happening to me wasn't right. Rachel's investigation expanded to examine why Craig would go to such extreme lengths to frame me. The OSHA complaint was serious and could result in fines and scrutiny, but destroying an employee with false criminal charges seemed disproportionate unless there was something bigger at stake. Rachel started looking into workplace injury records and workers' compensation claims at Riverside Distribution Center, and what she found suggested a massive fraud operation. Over the past 3 years, the company had filed 83 workers' compensation claims for injured employees, an extraordinarily high rate for a facility our size. But the pattern of injuries was suspicious. Most occurred during periods when Craig was supervising, involved similar mechanisms of injury related to safety violations, and resulted in claims that were quickly settled for relatively small amounts considering the severity of the injuries. Rachel dug deeper and discovered that Craig had a financial relationship with the insurance adjuster who processed most of Riverside's workers' compensation claims. The adjuster, a man named Dennis Farrell, worked for an insurance company that covered Riverside's liability policies. Rachel found bank records showing Dennis had been making regular payments to an LLC that Craig owned, payments that coincided with major workers' compensation settlements at the warehouse. The pattern suggested Craig was deliberately creating unsafe conditions that led to worker injuries, filing inflated insurance claims, and then splitting the settlement money with Dennis while pressuring the injured workers to accept minimal compensation. The injured workers, mostly immigrants and people with limited legal resources, didn't realize they were entitled to much larger settlements and accepted whatever the insurance company offered. This explained why Craig had reacted so aggressively to my OSHA complaint. The complaint documented systematic safety violations with dates, photos, and specific incidents. If OSHA investigated and found deliberate safety violations, they'd refer the case to law enforcement for potential criminal prosecution. Craig's entire fraud scheme would be exposed, along with his financial relationship with Dennis Farrell. Destroying my credibility before the OSHA investigation could proceed was essential to protecting his operation. If I was in jail facing felony theft charges, my complaint would be dismissed as the accusations of a disgruntled criminal trying to deflect blame for her own misconduct. The strategy had nearly worked. Gary filed an emergency motion to compel the prosecution to investigate Craig Donovan and Dennis Farrell for conspiracy to file false charges and workers' compensation fraud. He attached Rachel's findings showing the financial relationship between Craig and Dennis, the suspicious pattern of workplace injuries, and the evidence that Craig had pressured workers to provide false statements against me. Prosecutor Aaron Klein responded defensively, arguing that alleged insurance fraud was irrelevant to my theft charges, and that Gary was trying to distract from my criminal conduct with conspiracy theories. But Judge Leland was troubled by the evidence. She ordered an independent investigation into the workers' compensation claims and directed the prosecutor's office to cooperate with that investigation rather than obstruct it. The independent investigation was conducted by the State Insurance Fraud Bureau, and their investigators moved quickly once they understood the scope of the alleged scheme. They subpoenaed financial records from both Craig and Dennis, interviewed injured workers, and examined the pattern of claims and settlements. What they found was even worse than Rachel had suspected. Over 3 years, Craig and Dennis had orchestrated a fraud operation that netted them over $800,000 in illegal payments. Craig deliberately created hazardous working conditions, ensured that injuries occurred, and then filed workers' compensation claims that were inflated to include unnecessary medical treatments and exaggerated disability periods. Dennis, as the insurance adjuster, approved the inflated claims and authorized large payouts, then shared the money with Craig while pressuring the injured workers to accept settlements that were a fraction of what the insurance company actually paid. The injured workers were the real victims of the scheme. People who'd suffered serious injuries and deserved full compensation had been manipulated into accepting minimal settlements, while Craig and Dennis pocketed hundreds of thousands of dollars. Luis Gutierrez, whose broken leg had taken 6 months to heal, had accepted a $12,000 settlement when the insurance company had actually paid out $85,000 for his claim. Jennifer Park, who'd suffered a concussion and ongoing headaches, had accepted $8,000 when the payout was over $60,000. The pattern repeated across dozens of injured workers who'd been exploited while vulnerable and desperate. The Fraud Bureau filed criminal charges against both Craig and Dennis for insurance fraud, conspiracy, filing false claims, and theft from both the insurance company and the injured workers. Once Craig was arrested, the fabricated theft case against me collapsed rapidly. The insurance fraud charges gave prosecutors leverage to pressure Craig's accomplices to cooperate. The IT specialist who'd edited the surveillance footage, a man named Kevin Roth, agreed to testify in exchange for immunity. Kevin explained that Craig had ordered him to create a compilation of footage showing me removing boxes from the warehouse, telling him it was for an internal investigation into inventory management. Kevin had followed instructions without questioning why the footage was being manipulated. When he learned Craig had used his work to frame someone for felony theft, he was horrified and eager to cooperate. The security guard who'd been pressured to sign statements about my supposed suspicious behavior also came forward, explaining how Craig had threatened him with termination if he didn't support the theft narrative. Prosecutor Aaron Klein dropped all charges against me 6 weeks after my arrest. He issued a public apology saying the prosecution had been based on fabricated evidence and that I'd been wrongly accused as part of a retaliation scheme. But the damage to my reputation and finances was already done. I'd spent 5 days in jail, lost my job when Riverside Distribution Center terminated my employment immediately after my arrest, depleted my savings on legal fees despite Gary working pro bono, and lived under the shadow of pending felony charges for over a month. Job applications I'd submitted were rejected because the arrest showed up in background checks. Creditors were threatening me over missed payments. My apartment lease was in jeopardy because the landlord wanted to evict a tenant who'd been arrested for theft. Gary helped me file a civil lawsuit against Craig Donovan, Dennis Farrell, Riverside Distribution Center, and the insurance company for malicious prosecution, false imprisonment, defamation, and intentional infliction of emotional distress. The lawsuit sought damages for lost wages, legal fees, emotional suffering, and punitive penalties to deter similar conduct. Riverside initially fought the lawsuit aggressively, claiming they'd acted in good faith based on what they'd been told by Craig and that they couldn't be held liable for his criminal actions. But when Rachel's investigation revealed that senior management had been warned multiple times about safety violations and had ignored those warnings in favor of Craig's cost-cutting approach, the company's legal position weakened. Documents showed that HR had received complaints about unsafe conditions from multiple employees, not just me, and had consistently dismissed those complaints or retaliated against the workers who raised them. The criminal trial against Craig and Dennis happened 7 months after my arrest. I attended every day, sitting in the courtroom watching the men who'd tried to destroy my life face justice. The prosecution presented overwhelming evidence of the insurance fraud scheme, including financial records showing the illegal payments, testimony from injured workers who'd been exploited, and Kevin Roth's account of being ordered to fabricate evidence against me. Craig's defense attorney tried to argue he'd genuinely believed I was stealing and had reported his suspicions to police in good faith, but the timeline destroyed that narrative. The fabricated surveillance footage had been created before I filed the OSHA complaint, proving Craig had been preparing to frame me preemptively. When Craig took the stand in his own defense, the prosecutor shredded his credibility through cross-examination, forcing him to admit he'd pressured workers to sign false statements and had financial motives to silence my safety complaints. The jury deliberated for 9 hours before returning guilty verdicts on all counts. Judge Leland, who'd presided over my arraignment and the subsequent dismissal of charges against me, now sentenced Craig to 12 years in federal prison for insurance fraud and conspiracy. Dennis Farrell received 8 years. Both were ordered to pay restitution totaling over $800,000 to the insurance company and the injured workers who'd been cheated. Judge Leland's sentencing statement was scathing, condemning both men for exploiting vulnerable workers and for attempting to destroy an innocent person's life to cover their crimes. She noted that Craig had abused his position of authority to create a system of exploitation and retaliation that had damaged dozens of lives, and that only my determination to fight back had exposed the entire criminal enterprise. The civil lawsuit settled 3 months after the criminal convictions. Riverside Distribution Center's insurance carrier agreed to pay $950,000 to avoid trial, with the settlement including provisions that Riverside implement comprehensive safety reforms, cooperate with ongoing OSHA oversight, and publicly acknowledge the wrongdoing that had occurred under Craig's supervision. The insurance company that had employed Dennis Farrell settled separately for an additional $200,000, admitting no liability but agreeing to pay damages to make the case go away. The settlement money allowed me to rebuild my life after everything that had been taken from me. I paid off debts, compensated Maya for the bail money, covered Gary and Rachel's fees beyond their pro bono work, and had enough left to establish some financial security while I looked for new employment. Finding a job proved difficult because the arrest still appeared in background checks even though the charges had been dismissed and I'd been vindicated. Employers saw the arrest record and made assumptions before they heard the full story. I applied to dozens of warehouse and logistics positions and received rejections without interviews. Finally, I found work with a different distribution company whose HR manager had followed my case in the news and believed I'd been wronged. The new job paid less than my supervisor position at Riverside had, but the working conditions were dramatically better. Safety protocols were strictly enforced, workers received proper training, and management treated employees with respect. I worked there for 2 years, rebuilding my reputation and career, before being promoted to operations manager when my predecessor retired. The injured workers from Riverside received restitution payments from Craig and Dennis's criminal convictions, but many of them filed additional civil lawsuits seeking full compensation for their injuries and the exploitation they'd suffered. Gary's firm represented several of these workers pro bono, using the evidence from Craig's criminal case to secure substantial settlements. Luis Gutierrez received $240,000 for his broken leg and the disability it had caused. Jennifer Park's settlement covered ongoing medical treatment for her concussion symptoms and lost wages. Other workers received similar compensation, finally getting justice years after they'd been injured and cheated. Several workers told me that seeing Craig convicted and imprisoned helped them recover emotionally from the trauma of being exploited when they were most vulnerable. The OSHA investigation that had triggered everything concluded with findings of systematic and willful safety violations at Riverside Distribution Center. The company was fined $575,000 and placed under enhanced monitoring for 3 years. The report specifically cited Craig's deliberate disregard for worker safety and the company's failure to respond to multiple complaints from employees. Several senior managers at Riverside were terminated for their role in ignoring safety warnings and enabling Craig's conduct. The company's reputation suffered significant damage, with several major clients canceling contracts after learning about the safety violations and the criminal fraud scheme. Riverside eventually sold to a larger logistics company that restructured the entire operation and implemented strict safety and ethics policies. Kevin Roth, the IT specialist who'd been pressured to edit the surveillance footage, cooperated fully with prosecutors and avoided criminal charges. He contacted me through Gary and apologized for his role in what had happened, explaining he'd been manipulated by Craig and hadn't understood the consequences of his actions until it was too late. Kevin had lost his job at Riverside and struggled to find new employment with the scandal attached to his name. I didn't forgive him easily because his edited footage had nearly destroyed my life, but I understood he'd also been a victim of Craig's manipulation. Eventually, I wrote a letter to potential employers explaining that Kevin had cooperated with law enforcement and had been exploited rather than being a willing participant in the fraud scheme. Maya's support throughout the ordeal had been essential to my survival. She'd sacrificed financially to post bail, had connected me with Gary, had helped research Craig's background, and had never doubted my innocence even when the evidence looked damning. After everything was resolved, I tried to repay her both financially and emotionally. We'd always been close as sisters, but the shared trauma of fighting this injustice had deepened our bond in ways that felt permanent. Maya eventually left her paralegal job and went to law school, inspired by watching Gary and Rachel fight for justice. She wanted to represent people who'd been wronged by powerful institutions and couldn't afford elite legal help. 3 years after Craig's conviction, I was invited to speak at an OSHA conference about whistleblower retaliation and the importance of protecting workers who report safety violations. I told my story to an audience of safety inspectors, labor attorneys, and worker advocates, describing how reporting my boss had led to arrest and false prosecution, but how fighting back had ultimately exposed a massive fraud scheme and protected other workers from exploitation. The audience responded with a standing ovation, and several people approached me afterward to share their own stories of retaliation for reporting workplace hazards. Many had faced less extreme consequences than I had, but the pattern was consistent. Workers who spoke up about safety issues were often punished rather than protected. My testimony at that conference led to contacts with worker advocacy organizations and eventually to a position with a nonprofit that helped employees navigate workplace safety complaints and retaliation issues. I used my experience to guide other workers through the OSHA complaint process, warned them about potential retaliation, and connected them with legal resources when employers struck back. The work was fulfilling in ways my warehouse management job had never been, and knowing I was preventing others from suffering what I'd endured gave meaning to everything I'd been through. Some cases were straightforward, with employers accepting responsibility and making changes. Others required litigation and years of fighting, but the workers I helped knew they weren't alone. Craig Donovan's 12-year sentence meant he'd be in federal prison until he was nearly 70 years old. His appeals were denied, his assets were seized to pay restitution, and his family disintegrated as his wife divorced him, and his adult children refused contact. Dennis Farrell served his 8-year sentence and was released on parole after 6 years, his insurance career permanently destroyed, and his professional licenses revoked. Both men became cautionary examples in insurance fraud training courses and legal ethics seminars. The case was cited in academic papers about workplace retaliation and in advocacy efforts for stronger whistleblower protections. My name appeared in those papers too, usually with descriptions of the ordeal I'd survived and the reforms that had resulted from my determination to fight back. On the 5th anniversary of my arrest, I drove past the old Riverside Distribution Center building, now operating under different ownership with Midwest Logistics branding and a reputation for strict safety compliance. The parking lot where I'd been filmed carrying boxes, where that footage had been manipulated to frame me for theft I'd never committed, looked ordinary and mundane in the afternoon sunlight. Workers were loading trucks, forklifts were moving pallets, everything appeared normal and safe. I thought about the 18 people who'd worked under my supervision during those terrible months when Craig was creating hazards and exploiting injuries, about Luis Gutierrez's broken leg and Jennifer Park's concussion, about all the suffering that could have been prevented if the company had listened when I'd first raised concerns. The arrest had been the worst experience of my life, but it had also led to justice for people who deserved it, and reforms that would protect workers for years to come. Judge Leland, who'd presided over both my arraignment and Craig's sentencing, retired from the bench 2 years later and wrote a book about her experiences with wrongful prosecutions and malicious charges. She devoted an entire chapter to my case, describing how close the system had come to imprisoning an innocent person based on fabricated evidence and how essential it was for judges to question prosecutions that seemed motivated by retaliation rather than justice. She interviewed me for the book, asking about my experience in jail, my decision to fight the charges despite the risks, and what reforms I thought were necessary to prevent similar injustices. The book became required reading in some law schools and criminal justice programs, another lasting impact from the ordeal that had nearly destroyed me. 10 years after reporting my boss and being arrested for a crime I didn't commit, I stood at a podium accepting an award from the National Whistleblower Center for courage in exposing workplace fraud and safety violations. My daughter Elena, now 7 years old, sat in the front row with Maya, watching her mother receive recognition for something she'd eventually understand but was too young to fully comprehend yet. Elena knew her mom helped people at work and that she'd been through something difficult years ago, but the details would come later. I looked at my daughter and thought about the future I'd almost lost when Craig tried to destroy me with false charges, about the career and family and life that had been possible only because I'd refused to accept injustice. The award citation read that my actions had led to criminal convictions, regulatory reforms, restitution for exploited workers, and lasting improvements in workplace safety protections. Craig Donovan had tried to silence me by destroying my life, but instead I'd exposed him and built something meaningful from the wreckage he'd created. If you enjoyed this, you'll definitely want to see the next ones too, so subscribe now and let me know your take in the comments.